81st session of Legal Empowerment Through Interaction Lecture Series. Today, we have a short topic, that is police and magisterial inquiries into cases of unnatural and suspicious death. May I request Prem to do the introductory remarks?
Actually, there is no introductory remark. Now, this is a topic which we have a set of 22 questions. And I think Ramkumar sir had told me, even right now, he had told that he is having some voice problem. So I think we may directly go to the questions. Sir, can we?
No, before that, why not we discuss the chart? Then only we can
Okay. So just display the chart. Shyam, can you just screen share the chart?
Yeah, sure. Prem. Prem Gio.
അത് ഓപ്പൺ ചെയ്യട്ടെ നോക്കട്ടെ ഒരു മിനിറ്റ് ഓപ്പൺ ചെയ്തു വന്നുവോ?
Yeah, very good.
Yes.
Sir, chart is on.
Okay. One second. Okay. Now, before coming to the chart, sections 174 and 176 of the Code of Criminal Procedure, occurring in chapter 12, deal with the powers of the police officer and the magistrate respectively to find out the apparent cause of death by the police officer and real cause of death by the magistrate respectively in cases of under suspicious cases of death under suspicious circumstances or certain specified instances of unnatural death. Even though what is done by the police officer is part of investigation, the investigation on an inquiry under section 174 CRPC is entirely distinct from an investigation pursuant to the registration of an FIR under section 154 CRPC. Because proceedings under section 174 CRPC have only a limited scope. This is observed by the Supreme Court in Manoj Kumar Sharma versus State, AR 2016 Supreme Court 3930. The author is Justice R.K. Agrawal. The scope of proceedings by the police under section 174 CRPC is very limited. Its object is merely to ascertain whether a person has died under suspicious circumstances or an unnatural death, and if so, what is the apparent cause of death. This is the limited scope of a police inquiry or even a magisterial inquiry. Now we come to the chart. First chart is chart A. See, on the left hand side of chart A, you get the provisions regarding police inquiry, police investigation. On the right hand side of chart A, you get the inquiry by the magistrate. I will first read the left hand side, police inquiry. When the SHO or some other specially empowered police officer receives information that a person has committed suicide or has been killed by another, or has been killed by an animal, or has been killed by machinery, or has been killed by an accident, or has died under circumstances raising a reasonable suspicion that some person has committed an offense, the station house officer or the other specially empowered police officer shall, here the wording used is shall, immediately give intimation thereof to the nearest executive magistrate empowered under section 174(4) CRPC to hold the inquest. The section 174(4) enumerates the magistrates, executive magistrates who are competent to hold inquest. Then after intimation, he and proceed to the place where the body of the deceased person is, and there, that means the place where the body is, there in the presence of two or more respectable inhabitants of the neighborhood, make an investigation and draw up a report of the apparent cause of death. This is what the police officer, while holding an inquest, does. He does an apparent cause of death, which according to him, as is perceived by him, what is the apparent cause of death? And describing each such wounds, fractures, bruises, and other marks of injury as may be found on the body. We have got the inquest report described under the Kerala police manual. Likewise, every state has got the form of inquest report prescribed by the respective police manuals. Then stating in what manner or by what weapon or instrument, if any, such marks appear to have been inflicted. If they are visible and if they are ascertainable, he has to state that also. The report shall be signed by the police officer and other person who concur therein, and shall be forthwith forwarded to the district magistrate or the subdivisional magistrate. Section 174, clause 2 CRPC. When, then clause 3, when the case involves suicide by a woman within 7 years of her marriage, or 2, the case relates to the death of a woman within 7 years of her marriage in any circumstance raising a reasonable suspicion that some other person committed an offense in relation to such woman, or 3, the case relates to death of a woman within 7 years of her marriage and any relative of the woman has made a request in this behalf, or 4, there is any doubt regarding the cause of death, or 5, the police officer for any other reason considers it expedient to do so, then he shall subject to any state government rules, forward the body for examination, that is autopsy, to the nearest civil surgeon or other qualified medical man appointed by the state government. If the state of the weather and the distance so admits without risk of putrefaction, there's some disturbance. The distance so admits without risk of putrefaction on the road, rendering such examination useless. If the examination is rendered useless due to putrefaction, then of course he need not. Otherwise, he will have to send it to the nearest civil surgeon or other qualified medical man for conducting the autopsy. Then power of the police officer conducting this inquiry. Under section 175(1) CRPC, that section clothes the police officer proceeding under section 174 with the power to summon persons for the purpose of his investigation, and such person so summoned shall be bound to attend and to answer truly all questions other than questions, the answers to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. In fact, this is almost like section 161(2). Any person who is examined by the investigating police officer shall be bound to answer truly. Similar provision is there in section 175(1) CRPC also. Then section 175(2) enjoins that if the facts do not disclose a cognizable offence to which section 170 applies, such person shall not be required by the police officer to attend a magistrate's court. Now, that means under section 175(2), the enjoined that the fact do not disclose a cognizable offence to which section 170 applies, then such person shall not be required by the police officer to attend a magistrate court. Let me check up. I have some doubt whether it is correctly stated. 174. Yes, I don't know why such a provision, because if a offence falling under section 170 means there is a case for placing him on trial before the court, then I don't know why such a provision is there. I fail to notice the impact of this decision. Now we come to the second column, the magisterial inquiry. This is whatever we discussed on the left hand side column is police inquiry, police investigation. Then on the right hand side, we have got the magisterial inquiry. That is, when the case is of the nature covered by clauses 1 and 2 of section 174(3). That is clause 3, that is column 3, clause 3 of the first column, column 1 of this table. The nearest magistrate empowered, see, there the nearest magistrate empowered to hold inquest under section 174(4) CRPC, that is any district magistrate, subdivisional magistrate, or any other executive magistrate specially empowered either by the state government or by the district magistrate to hold inquest. He shall, and in any other case mentioned in section 174(1), which is clause, that is one of column 1 in this table, any magistrate so empowered. If it is clause 3 of column section 174, the nearest magistrate. Now, if it is other clauses, then any magistrate so empowered may hold an inquiry into the cause of death either instead of or in addition to the investigation held by the police officer. And if he does so, he shall have all the powers which he has while holding an inquiry into an offence. That is section 176(1) CRPC. Then we come to 1A, which was subsequently introduced by an amendment. Section 1, subsection 1A, where any person dies or disappears or rape is alleged to have been committed on any woman, while such person or woman is in the custody of police or any other custody authorized by the magistrate or the court under the CRPC, in addition to the inquiry or investigation held by the police, an inquiry shall be held by the judicial magistrate or the metropolitan magistrate within whose local jurisdiction the offence has been committed. See, when it comes to these two types of cases, the inquiry is to be conducted by a judicial magistrate, not an executive magistrate, not even the nearest executive magistrate or any other executive magistrate. Then subsection 2, the magistrate holding such an inquiry shall record the evidence taken by him in connection therewith in any manner hereinafter prescribed according to the circumstances of the case. That is section 176(2) CRPC. Then whenever such magistrate considers it expedient to make an examination of the dead body of any person who has already been interred, that is already been buried, in order to discover the cause of his death, the magistrate may cause the body to be disinterred and examined. Section 176(3) CRPC. Then 4, where an inquiry is to be held under this section, the magistrate shall, wherever practicable, inform the relatives of the deceased whose names and addresses are known and shall allow them to remain present at the inquiry. So at the time of inquest, the near relatives should be allowed to be present to watch the proceedings of the magisterial inquiry. The judicial magistrate or the metropolitan magistrate or the executive magistrate or even police officer holding an investigation under subsection 1A shall, within 24 hours of the death of the person, forward the body for examination, that is autopsy, to the nearest civil surgeon or other qualified medical person appointed in this behalf by the state government, unless it is not possible to do so for reasons to be recorded in writing. That is section 176, clause 5 CRPC. In the explanation, near relatives, which we mentioned, who can be permitted to watch the proceedings, this section, there is an explanation. This section, the explanation, expression relative means parents, children, brothers, sisters, and spouse. They are the relatives who can be permitted to watch the inquest proceeding. Now, I have given a chart A1, which is a combined effect of sections 174 and 176 CRPC. I'm not reading it, which is self-explanatory. You can peruse it after the lecture. Now we come to pass on to the questions. Can anybody read question number 1?
Question number 1.
Prem, can you just show it on the screen? Yeah.
Yes.
What is an inquest? Shyam.
Okay. An inquest is an inquiry to find out the apparent cause of death of a person who has died under suspicious circumstances. In England, such inquiry is conducted by a coroner or a medical examiner. Coroner is a public official whose duty is to investigate the cause and circumstances of any death that occurs suddenly, suspiciously, or violently. Among other things, the duties of the coroner consisted of holding an inquest upon dead bodies. A coroner's court in English law is a common law court that holds an inquisition if a person died a violent or unnatural death. Yes, so this is what is called inquest. Then question number 2.
I am covered by first one.
What is the purpose of an
Purpose. The main purpose of holding an inquest is to ascertain whether a person died under suspicious circumstances or met with an unnatural death, and if so, what is the apparent cause of death? That is mentioned by the section itself. Section 174(1) itself mentioned that. Then this has been so stated by various rulings of the Supreme Court. For example, Podda Narayana versus State of Andhra Pradesh, a year 1975 Supreme Court 1252, 1252. A year 1975 Supreme Court 1252. Again, George versus State of Kerala, a year 1998 Supreme Court 1376. Then Radha Mohan Singh alias Lal Sahib versus State of UP, AIR 2006 Supreme Court 951, 3 judges. There are other rulings also. So this is the purpose of inquest, to find out the apparent cause of death. Of course, police officer is making he does not make he makes a cursory examination of the dead body, and from the manner in which the dead body is found, he makes he holds an inquest to find out the apparent cause of death. His conclusions need not necessarily be final and may not necessarily be true also. A case where he finds that it appears to be murder, it can be suicide also, because there is no scientific or forensic confirmation of the cause of death. Question number 3.
Sir, in fact, the next question is a corollary to that.
Yes.
Should not the inquest report contain the incident, the manner in which the incident took place, name of the accused, etc.?
These are all matters which are to be stated in the final report, in the charge sheet. Now, inquest is not for that. Inquest is to find out the apparent cause of death. The inquest report need not contain the manner in which the incident took place, the name of the accused, etc. But of course, if the name of the accused is known, and if the panchayatdars who are present during the time of inquest, if they mention the name, nothing wrong in the police officer mentioning that.
It is only an inference drawn by the officer at the time of autopsy on conducting a preliminary. It's just like a preliminary inquiry as to the cause.
Inquiry, that's all. And how the incident took place, he is not an eyewitness. Of course, if there is an eyewitness who is present as a panchayatdar, he may be stating that I saw the occurrence. Then he can state that. But actually, that is foreign to the scope of inquest report. For that, decisions are State of UP versus Abdul, AR 1997, Supreme Court 2512. Kurdukar, Justice Kurdukar is the author. Then again, Sheikh Ayub versus State of Maharashtra, AR 1998, Supreme Court 1285. AR 1998, Supreme Court 1285. Then again, Amar Singh versus Balvinder Singh, AR 2003, Supreme Court 1164. AR 2003, Supreme Court 1164. GP Mathur, Justice Mathur. Then Brahm Swarup versus State of UP, AR 2011, Supreme Court 280. The judges are Justice Sadashivam and Dr. B.S. Chauhan. Dr. Chauhan is being the author. Now, substitution of the correct name of the informant in the inquest report subsequently in a particular case was justified by the Supreme Court, because the name was subsequently corrected. Name was corrected. There was no foul play in that. Therefore, Supreme Court justified that. That is in State of UP versus Ram Swarup, AR 1988, Supreme Court 1028. AR 1988, Supreme Court 1028. Non-mention of the names of eyewitnesses in the inquest report will not render their testimony unreliable, because it was argued that when that particular witness was in the witness box, the defense raised a contention that his name does not figure in the inquest report. That is not necessary. Therefore, non-mention of the eyewitness's name in the inquest report will not render his testimony in court unreliable. That is Kuji alias Surendra Tiwari versus State of Madhya Pradesh, AR 1991, Supreme Court 1853. 3 judges. AR 1991, Supreme Court 1853, 3 judges. A. Mohammadi is the author of the judgment. Now we pass on to question number 4.
Prem.
Question number 4. Question number 4, it relates to the very section itself. Is it necessary that the inquest should be held at the spot where the dead body is found?
Yes, while I emphasize that portion of section 124. Section 124, 1 CRPC says, the nearest executive magistrate shall proceed to the place where the body of such deceased person is, and there, in the presence of 2 or more respectable inhabitants of the neighborhood, shall make an investigation. Therefore, there are situations where the police officer is informed when they, after the, supposing after the occurrence, the body is shifted to a hospital, and he died, he succumbed to the injuries in the hospital. Then the hospital people will say, immediately shift the body to the mortuary. So when the police is informed, the dead body will be in the mortuary. So when there means, if it is the police is getting the information at a time when the dead body is in the mortuary, they hold the inquest in the mortuary itself. Or if the dead body is lying at the place of occurrence, itself. That is what the section says. Kodali, we have mentioned that Kodali Puranchandra Rao versus public prosecutor. AR 1975, Supreme Court, 1925, 3 judges, Justice Chandrachud, B.N. Bhagavati, and R.S. Sarkaria. Justice Sarkaria is the author. This decision on another point may not be relevant in view of the statutory intervention, legislative intervention. Question 5.
The next question is very relevant in the sense like is it correct to say that the FIR loses its authenticity if it is lost after the inquest is held?
Because normally police get an information regarding the commission of a cognizable offence. As soon as the information is received, they register an FIR. So it is invariably after registering the FIR that the inquest is held. Therefore, if the inquest does not refer to the FIR is lodged after the conduct of the inquest, it loses its authenticity. That's what the Supreme Court said in that is Shambhu Das alias Bijoy Das versus State of Assam. AIR 2010 Supreme Court 3300. AIR 2010 Supreme Court 3300. Dr. Mukundagam Sharma and H.L. Dattu. H.L. Dattu is the author of the judgment. Also contains a discussion as to what all should an inquest report contain. This decision also contains this detailed discussion as to what all should be the contents of an inquest report. Question number 6.
Question 6. Do not discrepancy, overwriting, omission, or contradiction.
No.
I'm sorry.
Interpolation of an
Will interpolation in the inquest report render the prosecution case doubtful?
Answer can be either way, but in one case, Supreme Court said it is a serious, it being a serious interpolation made in the inquest report with a view to fit in with the new case concocted and found to render the prosecution case doubtful. There, the Supreme Court did not noted that it is a serious interpolation which renders the prosecution case doubtful. The citation is State of Haryana versus Shibu alias Shiv Narayan, AR 2009, Supplementary SCC, Supplementary Supreme Court 20609. Corresponding SCC is 2008, Volume 11 SCC 377. 3 judges. Justice Arijit Pasayat is the author of the judgment. Then question number 7.
Prem, you can take that. 7.
Do not discrepancy, overwriting, omission, or contradiction in the inquest report render it liable to be eschewed from consideration.
Yes, in the earlier question we saw that if it is a serious interpolation, the court may find it doubtful. But not every discrepancy, every overwriting, every omission, unless the above aspects have been put to the author, because there may be, the author should know, the author should be told that there are such corrections found in the inquest report. He is the author of the inquest report. The investigating officer, while he is in the witness box, the defense has to ask him questions. We find some overwriting, some corrections. What have you got to say? Unless his explanation is not elicited, it may not be available for the defense to argue that because of this overwriting, etc., reject the inquest report. No. An explanation should be sought from the investigating officer while he is in the witness box. Radha Mohan Singh versus Lal Sahib, State of UP versus State of UP. AR 2006, Supreme Court 951, 3 judges. Where the case of the prosecution is strong and substantiated by reliable evidence, lapses including overwriting in the inquest report may not be relevant. Sukhwinder Singh versus State of Punjab, 2014, volume 12, SEC 490, Ranjana Prakash Desai. Then in another case, where the discrepancy in the date of lodging the FIR mentioned in the inquest report was not put to the author of the inquest report, it was held that the request by the defense to draw an adverse inference was turned out by the Supreme Court. Radha Mohan Singh again versus alias Lal Sahib versus State of UP, 3 judges, 2006, volume 2, SEC 450, corresponding to AIR 2006, Supreme Court 951. Question number 8.
Sir, if the prosecution is supposed to prove the guilt beyond any reasonable doubt, is it open for the defense to falsify the prosecution version by relying on a document produced by the prosecution but not exhibited or formally proved by the prosecution?
The prosecution, there may be various reasons why prosecution, which has produced a document before court, may refrain from getting it marked. It may be adverse to their interest. Therefore, prosecution may not be interested in marking that document, which may be against the prosecution. In such a case, the question is whether it is open to the defense to get that marked, get that document marked and rely on that. Supreme Court said yes. Ramaya alias Rama versus State of Karnataka, AIR 2014, Supreme Court 3388. Justice Chalameshwar and A.K. Sikri being the author of the judgment. AR 2014, Supreme Court 3388. Question number 9.
Number 9. Is it usual to mention in the inquest report a gist of the FIR and the cause of death as narrated by the witnesses?
Normally it is done because inquest is conducted, as we noticed, inquest is conducted after the registration of the FIR. FIR will give a gist of the, from the FIR, the officer can get a gist of the occurrence and etc. Therefore, normally inquest report will contain gist of the FIR, etc. That is why in Tanedar Singh versus State of Madhya Pradesh, AR 2002, Supreme Court 175, 3 judges. Venkatarama Reddy is the author of the judgment. They said it is usually done because inquest is invariably prepared after the registration of the FIR, and FIR has got the, you have the preliminary information regarding the occurrence. Therefore, that is usually incorporated in the report. Then, in one case, substitute of the correct name of the informant in the inquest report subsequently made was justified by the Supreme Court. AR 1988, Supreme Court 1028. That is State of UP versus Ram Swaroop. AR 1988, Supreme Court 1028. 3 judges. Jagannath Shetty is the author of the judgment. In yet another case, omission to mention crime number in the inquest report held not material if there was other evidence to show the registration of an FIR earlier. The inquest report did not contain the crime number, etc. But there was intrinsic evidence to show that an FIR had been registered prior to the conduct of holding the inquest. Therefore, the Supreme Court accepted that. Dr. Krishna Pal versus State of UP, AIR 1996, Supreme Court 733. Question number 10.
Sir, usual phenomenon. It depends upon, show me the face and I show you the rule. At times, evidence disappears. Since the SHO is doing an official act in the act of preparing the inquest report, etc., can he be guilty of causing disappearance of evidence of offense punishable under section 201 IPC?
He cannot he cannot act under the pretext that he is doing an official act. So everything should be regularity and honesty. Everything should be presumed. He cannot. There can be situations where an investigating officer may indulge in unscrupulous methods. So Supreme Court in that Kodali, same Kodali Purichandra Rao versus Public Prosecutor Andhra Pradesh, AR 1975, Supreme Court 1925, held that there can be situations, you can't say that he is doing an official act, therefore everything has to be presumed to be normally done, properly done. No, there cannot be any presumption. Ordinarily, of course, it can be presumed, but there can be situations where there are intrinsic material to show that he did not act honestly. In that case, on receiving information about the recovery of dead bodies, the sub-inspector, feigning ignorance and flouting all statutory requirements of Section 174 CRPC, prepared false records regarding the identity of the dead bodies, cause of death, and indulged in falsification of data, etc. That is why the Supreme Court said that he cannot take umbrage of official act. No, there can't be any such presumption. He cannot take umbrage of official act. Question number 11.
Question 11 that pertains to a very short judgment. I think it's an interim order, reported interim order. In spite of a written application to the police to investigate into the alleged murder of his sister, married to one of the accused persons, the police did not register it as an FIR. From the very beginning, the police were attempting to treat the case as one of suicide. If there are circumstances to justify an investigation into the allegation of suspicious murder, is it permissible for the court to direct the police to register the written application as an FIR?
You are right. That is what the Supreme Court did in Joint Women's Program versus State of Rajasthan, AR 1987, Supreme Court 2060. The judges are MP Thakur and BC Ray. So court, in appropriate case, court can direct the police to register an FIR. In fact, if you will recollect, in the case of the suspicious death of that film star, Sushant Singh Rajput, we had seen his heartbroken father complaining that when he called the SHO and reported about the suspicious death of his son, the SHO is alleged to have asked him to go over to the police station and give a written complaint. This was actually contrary to Section 154(1) CRPC, as per which any information regarding the commission of a cognizable offense, if given orally or in writing, should be reduced to writing. If given orally, should be reduced to writing and a case registered. So that SHO was not acting according to law. So we had seen that in various channels. Question number 12.
There is a technical doubt. Are the statements of witnesses given during the inquiry under Section 174 CRPC governed by Section 162?
Yes. Now, very often it is mistaken that this is only a police inquiry. So where is the question of it being hit by Section 162? Whatever the investigating officer does, police officer does while holding an inquest is also an investigation under Chapter 12. Therefore, the hearsay, whatever he collected from witnesses or whatever he did not perceive by his own senses are hit by Section 162. The bar under Section 162 is applicable because Section 174 also occurs in Chapter 12 CRPC. 162 applies to all investigations under Chapter 12, and 174 is also an investigation as under Chapter 12, as indicated by Section 175, which says it is investigation. Therefore, the bar under 162 will apply to an inquest proceedings also. AR 1975 Supreme Court 667 Rasik Ram versus J.S. Chauhan. Year 1975 Supreme Court 667. Judge R.S. Sarkaria is the judge. Then in AR 1977 Supreme Court 1066 also the same view was taken. But then a question may be asked, when the unnatural death or the suspicious death supposing a dead body is found, is found on where is the question of the police registering an FIR? And is it an investigation under that is clarified by Section 175 that it is investigation. Then if an offense is not disclosed, where is the question of police registering an FIR? In various state police manuals, it is stated that when there is an unnatural death discovered, police have to register an FIR. In Kerala also, police manual says that he has to register an FIR. Probably the I have not checked up the new police act of 2011. That also may contain a provision, if not the police manual, that they have to register. Likewise, in man missing case, there is no offence prima facie disclosed. In the course of inquiry, an offence may be disclosed. Until an offence is disclosed, there is no justification for registering an FIR under section 154 CRPC. But then the Kerala Police Act says, if in man missing case, register an FIR. This question came up for consideration in that Vidura murder case, I think. Vidura or Suryanelli murder case. The authors were Justice Basant and the author was Justice late Justice Abdul Rahim, sitting along with Justice R. Basant. They dealt with this aspect. Question 13.
Question 13. Which is the enabling power of an SHO to hold an inquest over a dead body?
Section 174.
We have already seen.
Undoubtedly, we have already seen. Question 14.
And that question also, it's the same wording as a statute, because even in many rulings of the apex court, we see conducting inquest.
Holding, it is actually holding inquest.
Actually, it's holding. We are seeing conducting the inquest.
Prem, go for 14.
14. Should not the SHO obtain the permission of the executive magistrate for holding inquest of the dead body of a person believed to have died an unnatural death?
No. The police officer need not obtain the permission. What section says is intimate. He need only intimate the executive magistrate empowered to hold an inquest. That is, and it was so held also by the Supreme Court in Madhu versus State of Karnataka, AR 2014 Supreme Court 394 by Justice Dr. B.S. Chauhan. Yes.
Madhurakan. 15.
Yes.
15, it pertains to an old law. Has not the SHO the discretion not to send the dead body for postmortem examination in a case where he entertains no doubt regarding the cause of death?
There can be a situation where the SHO, after holding inquest, does not entertain any doubt about the cause of death. In that case, the earlier position was, as held in Kodali, Purichandra Rao versus Public Prosecutor, Andhra Pradesh, AR 1975, Supreme Court 1925, 3 judges, and Justice R. S. Sarkaria is the author of the judge. It was held that if he does not entertain any doubt regarding the cause of death, he need not send the dead body for postmortem, for autopsy. But there is a statutory intervention after that, with effect from 23/12/1983, in subsection 3 of section 174. After the statutory intervention, the 75 Supreme Court is no more good law. Yes.
16.
Yes.
Is it not correct to say that both the inquest report and the postmortem report are substantive evidence?
They are not substantive evidence. Both are not substantive evidence. They are only corroborative evidence. And it has been so declared also by the Supreme Court in AR 2014, Supreme Court 394, Dr. B.S. Chauhan, Madhu versus Madhurakant,
right?
This is
Madhu alias Madhurakant, State of Karnataka.
Yes, Madhuranatha versus State of Karnataka, Dr. Chauhan. Yes, question
17 is, are not postmortem report and inquest report public documents? And is it not the accused entitled to inspect or receive their copies during the stage of investigation?
The answer is no. They are not public documents, and the accused is not entitled to inspect or receive copies of those reports during the stage of investigation. But after the charge sheet is filed, they are certainly. State versus Gyan Singh, 1981 Criminal Law Journal 538, Delhi High Court, by Justice M. Jain. 1981 Criminal Law Journal 538, Delhi. And again, the accused will be entitled to copies in the interest of fair trial, but only at the proper time, was another decision of the Bombay High Court. Palani Swami, we have Vayapuri versus State, AR 1968, Bombay, I'm sorry, 1968 Criminal Law Journal 453, Bombay High Court. The author of the judgment is Justice Naik. 1968 Criminal Law Journal 453. Question 18.
Question 18. Are not the statements in the inquest report as to what the SHO saw and found on the dead body hit by section 162 CRPC?
As in the case of any Mahazar, any Panchanama,
Right.
whatever the investigating officer sees, perceives with his own senses, supposing he has got a bad smell, he can mention that in the supposing he has seen blood-stained earth or blood-stained clothes, blood-stained weapon, he can say that. Likewise, whatever he actually perceives by his senses, they are not hit by 162. But whatever he has gathered from others, whatever information which he has gathered from others and has incorporated in the inquest report, it is hit by section 162. Like as in the case of the Panchayat Das, who are questioned at the time of inquest, whatever they say and which is not perceived by the police officer, they are hit by section 162. George versus State of Kerala, AR 1998 Supreme Court, 1376, M.K. Mukherjee is the author. George versus State of Kerala, AR 1998 Supreme Court, 1376. Question 19.
Are the statements of witnesses recorded by a police officer at the time of inquest during an inquiry under section 174 CRPC subject to the embargo under section 162 CRPC?
Yes, I already answered that. It is because it is also investigation under chapter 12. Section 162 1 says any investigation under no statement made to a police officer during the course of investigation under this chapter. 174 is also under chapter 12. Therefore, the embargo, the interdict under section 162 applies. Therefore, whatever statement is given by the witnesses to the police officer at the time of inquest will be hit by 162. They can be when the witness is in the witness box, it can be elicited. A contradiction alone can be elicited while during his examination, cross-examination.
Sir, we can conclude today's session by asking one final question with Prem.
But I'll give the citation also here. AR 19, that is Datar Singh versus State of Punjab. AR 1974 Supreme Court 1193. There are ever so many decisions by Justice M.H. Beg and Y.V. Chandrachud. Then Periyasamy versus State of Tamil Nadu. 1997 Criminal Law Journal 219. Dr. Anand and K.T. Thomas. Justice K.T. Thomas is the author of the judgment. There are ever so many judgments. Yes, you wanted some.
Sir, finally, I will ask, what exactly is the purpose? What exactly is an autopsy? And what is the significance of an autopsy?
Inquest we have already seen. Apparent cause of death. By the inquest to be held by the police officer. Apparent cause of death. Because he has only that much knowledge and he is only seeing the dead body, the corpse. He is only seeing the corpse and making his own deductions. That's all. He is not making any internal examination, etc. Now, the word autopsy is derived from the Greek word autopsia, which means the art of seeing for oneself. An autopsy is the medical examination of a corpse to determine the cause of death, especially in criminal investigation. It is also called postmortem or necropsy. Necropsy is also called. Autopsy is also called necropsy. An autopsy or postmortem examination may be performed to determine the cause of death or to observe the effects of disease and to establish the evolution and mechanism of disease processes. This is the purpose of autopsy. Whatever which is, in fact, by and large, an autopsy may conclude the real cause of death. Of course, there are certain cases where the viscera, the contents of the viscera may have to be sent to the chemical examiner or forensic expert for analysis, or blood etc. may have to be sent to the forensic expert for analysis. Then only the final report will be received. Otherwise, autopsy is gives the final conclusion regarding the cause of death, unlike an inquest report, which is only apparent cause of death. Question number 21, the last question for the day. Same. What is the purpose of an autopsy? Yes. The purpose of an autopsy, particularly forensic autopsy, is to determine whether or not death was due to natural causes or as a result of any crime or disease. In medico-legal cases, autopsy is important for the evolution of the circumstances of death and may be critical in establishing the mode of death like suicide or homicide. A postmortem report will contain details of injuries through scientific examination as against an inquest report, which is primarily intended to find out the nature and injury and the apparent cause of death. This is what so held by the Supreme Court in Sunil Singha versus State of West Bengal, 2007. I'm sorry, this is not Supreme Court, Calcutta High Court. 2007 Criminal Law Journal 516, Calcutta High Court. Judges are P.N. Sinha and P.S. Datta. P.S. Datta being the author of the judgment. That is what the so this much to be noted with regard to the inquest. Investigation by it is an inquiry by a police officer on the one hand, and an inquiry by the executive magistrate on the other hand. In certain cases falling under section 176 clause 1A, the inquiry should be by the judicial magistrate, not executive magistrate. That's it. There lies the difference. The chart is very self-explanatory. One goes through the chart. If one goes through the chart, you get the complete grip of the situation.
Sir, I mean, the person who in fact was instrumental for this session was Sudesh. Sudesh, are you there?
Yes, he
Yeah, Sudesh. Yeah, very much. Yeah. Sudesh. Yes, unmute.
Yes. Good evening, sir.
good evening.
Good evening, sir.
You only
So
wanted the
yeah, sir.
unnatural, the suspicious, etc. Now, the chart is very self-explanatory.
Yes. Shall I ask a question? Whether the executive magistrate have power to direct the police to register a crime?
Executive magistrate can also not direct. Executive magistrate can be an informant. Anybody can be an informant. Need not be a magistrate, need not be even a person who has not witnessed the occurrence, who has only hearsay knowledge about an occurrence. He can be the informant for registering an FIR. But executive magistrate cannot direct the police officer to register an FIR. But if there is information showing the commission of a cognizable offense, now after Lalita Kumari case, the police officer is bound to conduct an investigation unless the case is covered by any of those categories of cases where a preliminary inquiry can be conducted prior to the registration of a crime. For example, corruption cases, medico-legal cases. There are those 5 categories of cases enumerated by Lalita Kumari. Barring those cases, yes.
Another doubt, sir, is under 174, the police are giving a final report to the executive magistrate.
Yes.
Whether that original report is necessary for the magistrate to, when a complaint is filed by a party saying that there is an accused or one person is involved in a crime.
Yes.
Can a magistrate call for that report to the police or that report to the court or the police report?
No, normally what happens is, if after the investigation under section 175 by a police officer proceeding under section 174, he comes across that the death of the person was on account of a crime committed, then even though the original intimation was given to the executive magistrate, where the entire files are pending, once an offense is disclosed, then he will make a request to the executive magistrate to transfer all the records, including the FIR register, to the judicial magistrate concerned. And thereafter, it is the judicial magistrate who will proceed further. Once a crime is registered, as in the case of a suspicious arrest, etc., when a person is arrested for preventive arrest, etc., 151 CRPC, in such case, if within 24 hours an offense is not incorporated, the police officer is bound to release him. And if he does not do that and produces him before the magistrate is bound to release him. No other go, because no offense is made out, is incorporated within 24 hours. 24 hours is the maximum time the police officer can keep him in custody. therefore under detention. Therefore, once an offence is not incorporated, the police officer and the magistrate are bound to release it. That's what the Supreme Court also said.
So wonderful.
Likewise
class.
here also, after registering an FIR under 174 regarding unnatural death, if the investigation reveals the commission of a cognizable offence, say murder, etc., then the police officer, while giving the report, final report, will say that an offence is disclosed, cognizable offence is disclosed. Therefore, please transmit all the records to the concerned judicial magistrate, who alone can thereafter deal with the case.
Thank you, sir. Wonderful class, sir. Very good.
Shyam, we are indeed
Sir,
indebted
sir,
to
one
you
more
in
doubt
suggesting
regarding
the topic.
Yes.
one more doubt regarding Iqbal Singh Marwa's case. That's a very complicated issue now.
Yes.
Iqbal Singh Marwa, custodial legacy.
Custodial.
Legis. And there's a difference between 340, section 340
yes, there, full the constitutional bench, is it not?
Yes.
Constitutional bench. They affirmed the earlier decision to say that if the what is that, forgery was committed after the production of the document in court, then the document is custodial legis. So forgery, if it is committed after its production in court, then only 340, 195, 1B, read with section 340 will have to be conducted. Otherwise, if the what is produced in court is a fabricated document, already fabricated document, then 340 is 195 to read with 340 is not attractive. That is the law.
Yes.
Ordinarily, such an offence will be committed normally not by the accused but by the court staff. Certainly, with the connivance of the court staff, it can be committed. With the connivance of the court staff, there can be a fabrication of document while in the custody of the court.
Yes. Thank you, sir.
Thank you. Thanks, in fact, we are thankful to you for suggesting this topic. And we have our faculty who had addressed us earlier, Judge Sri Krishna Dadlia. Please, sir.
Thank you, sir, for the enlightening lecture.
Thank you.
Sir, you told that the purpose of police investigation under section 174 is to know the apparent cause of death.
Cause of death.
Is it the same purpose for magisterial inquiry as well?
No, magisterial inquiry, of course, police, magisterial inquiry also, he is only causing an inquest to be conducted, inquest to be held. Magistrate can cause an inquest to be held. He can even get a body disinterred. All those things. But the conclusive proof can come only after conducting an autopsy, which also the magistrate is authorized to do under the section 176. Magistrate can send the body to the nearest civil surgeon for conducting an autopsy. The only autopsy alone can conclusively show the real cause of death. And autopsy, as I said, may not be conclusive. Supposing some body fluids, viscera, etc., have to be. For example, if it is a death by administering poison, then the autopsy may not be conclusive. Then the viscera will have to be, a sample of viscera will have to be sent to the chemical examiner for examination. And if the chemical examiner says that this is poison and he identifies the poison, then you can conclude that death was by poison.
Once an FIR has been registered, and the police has decided to conduct an investigation under section 157, what is the need of 174?
No, 154 registering FIR is only when the cognizable offence is disclosed. But here, supposing a dead body is found, on the street, or suspicious death or unnatural death, then nobody knows whether any crime has been committed.
In those cases, this is helpful. But in case
154 does not apply. 154 does not apply because there is no information regarding the commission of a cognizable offence either under section 154 or 157. 157 is also information or otherwise. That otherwise can be, supposing police officer is going on night patrol duty. He comes across a person in a suspicious circumstance, he stops him and makes a body search and finds some ganja or something like that, then that is otherwise. Otherwise means not on information but on his own personal knowledge. Right in the presence an offence is committed. Such things are contemplated or taken in by otherwise, not on information.
Thank you.
Information is 154.
Thank you.
Sir, Dilip sir.
Thank you. Good evening, sir.
Really.
I dare ask this doubt with the caveat that my ignorance will be excused.
I have also similar caveat. I can only answer to the best of my knowledge, information, and capacity.
With regard to the statement made to the police officer during investigation, which is barred under section 162, can such a statement be equated to a report made by the police officer after inquest?
Supposing that report contains matters which he gathered from others,
Only that, but
that part of the report will be hit by 150.
yes.
Not those things which he perceived by his senses.
Right. Then the next question will be like, suppose in 162 statements, the witnesses are not allowed to, or the 162 statements are not allowed to be signed by the witness.
Yes.
But the report says that, because the report says that can be signed by witnesses or who concurs with the police officer. So, wouldn't that document?
You mean the attesters?
Attested. Not signed by concurrent witnesses.
Then they are the panchayatas who are the witnesses to the inquest.
That's respectable in the present. The inquest is made or held in the presence of
respectable inhabitants of the locality.
Locality need not be,
Yes.
but the report has to be signed by the persons who concur with the investigating officer.
Yeah, it's just like signing a magasar.
But then, if any information is elicited from such persons, that will be hit by 150.
That will be it. So,
and Supreme Court has gone to the extent of saying that even supposing an information elicited from a witness, not in the manner of his statement. His statement is not appended to the inquest report, but information collected by the investigating officer after questioning him and incorporated in the inquest report in the words of the officer, police officer, not in the words of the witness, but in the words of the police officer, that also will be hit by 150. Because no statement, whether in a police diary or otherwise, 162(1) is very, very broadly stated. No statement made by any person. See the wording, 162, very, very broadly stated.
No statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced in writing, be signed by the person making it. Nor shall any such statement or any record
or any record thereof, whether in a police diary or otherwise. See, I was so widely stated. That is why in one case, I think it is Keshav Singh's case, one case, there's instead of questioning the witnesses, police officer took a letter. He asked a witness through a communication about the occurrence, and the witness gave a reply letter. And the question was whether it is hit by 162, because he is not orally, because 161 says any police officer conducting an investigation may orally examine. Now there was no oral examination. So, see, there was no oral examination under 161. Therefore, it was argued that there is no oral examination. Therefore, it is only a communication and a reply, correspondence between the police officer and the witness. So, it is not hit by 162 was the argument. Supreme Court said nothing. 162(1). So broadly stated. Like if that is so, then every investigation can be through communication, through correspondence. You can get over the bar under 162.
So I think that came in the case of an accident case. It appears getting at
no
information.
even otherwise. I don't remember the citation.
Normally there will
Premraj may be knowing the size.
No,
Keshav
normally
Singh
they
No,
will give a letter
there is
to
a-
the
73 Supreme Court is there, 84 Supreme Court is there. Two decisions of the Supreme Court.
No, there's a latest ruling by the Kerala High Court by Justice
Yes.
Pisharadi,
Yes,
2024 KHC 355.
yes. Same point.
Same point.
Is 73 Supreme Court relied on or 84 Supreme Court relied on?
No.
Both they are direct rulings of the Supreme Court. 73 and 84. Keshav Singh or I don't remember the name. 73 Supreme Court and 84 Supreme Court. Two decisions of the Supreme Court. I had followed that in a bank fraud case where the question was very interesting. The investigating officer, it was a bank fraud case where a fictitious account was taken in the name of somebody. The the accused opened an account in the name of somebody else and got amounts transferred, etc. Then the question was, the investigating officer wanted to find out whether this is a fictitious person, the person who started the account. So he sent a registered letter to that address, and the postman who attempted to serve the letter was found that it is a fictitious address, no such person. He returned the postal article with that endorsement. Then those correspondence were produced before court to say that I tried to find out whether he is a fictitious person or real person by sending a registered letter to that address, and the postman returned that address by saying that no such address is a fictitious person. That is sought to be marked in the case. And I, following this decision, I held that those communications are inadmissible because you can examine the postman. The investigating officer can examine the postman, not a communication from the postman, which will be squarely hit by 162. Following this 73 Supreme Court and 84 Supreme Court. I don't remember.
73. Kaliram.
Kaliram, right? You are right. Absolutely right.
Vinod, 84 is Vinod Chaturvedi.
Maybe.
Will it not the presumption under the Post Office Act will apply?
Nothing like that.
27, because when an article has been sent in a particular address and it has been returned by either unclaimed or refused or with endorsement that no such address here.
For the sender, it may be valid. For an investigation officer, it is not valid. Not enough. It's not primary evidence also.
So you'll have to prove that, you'll have to say that you'll have to prove
postman will have to depose. This is the postal article. This letter I received from the investigating officer. I made inquiries and tried to attempt a service of that postal article. I could not find the etc. He will have to say.
So ultimately, the inquest report, if it contains any statement of the witness, is barred.
Yes.
But if it doesn't contain any statement, only a report by the police officer without any statement, is it admissible?
It is admissible. Whatever he has seen from the dead body, he is holding an inquest. So he is holding an inquest to find out the apparent cause of death. So whatever he is found in the dead body, he will explain the injuries on the dead body. Supposing there is a weapon lying near the dead body, because he has to hold the inquest at the exact place where the dead body is found. Therefore, supposing near the dead body there is a weapon or a blood-stained clothes lying, blood-stained earth lying, he can he can describe that in the inquest report. That is all not hit by 162. But if some witness tells him some fact which is incorporated in the inquest report, that will be hit by 162. As in the case of a scene master, supposing scene master, invariably no police officer will witness a crime unless it is committed in front of him. So when a police officer receives information regarding the commission of a cognizable offense, the police officer goes to the place, scene of crime. He will ask, who has seen the occurrence? You show me the place of occurrence, scene of occurrence. And an eyewitness will show him the scene of occurrence. He will describe the scene of occurrence in the scene master. He will also take into custody the incriminating article found there. Though that taking into custody the incriminating article found by him is admissible because he has perceived it. But the statement of the witness that this is the place of occurrence, this is not seen by the investigating officer. Is told to him, he was told by a witness that this is the place where occurrence took place. That is, he is described that in the scene. That part of the scene master will be hit by 162.
162, 160. Yes, I understand. Then the last question, that's only a misreading. I don't know whether it's a misreading. He shall inform, give intimation thereof to nearest executive magistrate empowered to hold inquest.
Yes.
And the inquest is done by the SHO.
Usually, actually, it is expected to be done by the executive magistrate. But in practice,
it is being done in the presence of the executive magistrate, but as prepared by the.
He will be a mute spectator.
Second subsection 2 also says the report shall be signed by such police officer and other persons. The report has to be sent to the executive magistrate himself.
Yes.
Thank you, sir. Thank you.
May I ask?
Before I come to Prem and Rao, sir, can I ask Ramesh, sir, please?
I have missed the major portion of the discussions and also the question answer because some guest has come unexpectedly. So I will have to leave. That was the reason I sent a message to Prem and
I got it.
Shyam. And if possible, I will join if they go quick. See, anyhow, it's though it appears to be not a much importance in the part of the investigation, but it also plays a great role. And whatever lapses in the inquest report or things which are expected to be done or which are seen there not taken care of, that also will have some impact. Suppose some certain materials were found there and the investigating officer seizes of it. And even because and suppose it is not sent for examination for the purpose of finding out whether it contains any incriminating circumstances or not. Yes. Then it will be hit because normally it is material evidence that is likely to be obtained by sending it for examination is also having some impact. So yes. It is just like conducting an inquiry in respect of scene of occurrence, scene of crime. Yes. Same importance will have to be given for conducting the this because as far as suppose in the case of a suicide, body is seen on hanging, then it is a scene of occurrence. So yes. Things will be there. Normally what happens is in the case of hanging, people will be removed and then put it on the this thing, then thereafter they will inform. That may also happen because they may be under the impression that if there is little life is there, likely to save them. That is the purpose. And suppose the incident occurred in a particular place, the serious injuries, if the life is there, immediately they will take you to the hospital. Then it will become not the it will become a scene of occurrence, not the scene of inquest or a body found. So these things will happen, but this is also having the same importance of that was reason in one of the cases I think Justice Thomas has said. This is also as good as a collecting of material evidence available at the place of occurrence or at the place scene of body where it is being found. Those are on the body.
But inquest has to be conducted at the place where the body is found.
Body is found. That depends. Suppose in a case where death occurs on the same place, information came, the police rushed to the place.
Exactly.
Then thereafter only they will be taken to the postmortem, etc.
Yes.
Then it will become.
There are inquests which are held in the mortuary.
Most of the cases it happens.
Yes. When the police is informed by the hospital, body will be in the mortuary.
Yeah, because they will say that the body brought dead or person brought dead. So that will be normally the case. It will be normally they will be shifted to the mortuary. It will be on the mortuary table. Immediately the police come. Suppose it is after 6 o'clock, they will conduct it. It will be there only in the morning. They will conduct it.
And you know, in private hospitals, many doctors do not certify death by coming to our house. A near relative of mine died in the house. Aged woman. She was 85. We contacted so many hospitals. No doctor was willing to come to the house for certifying death. No, then you know what happened? We informed. Then one hospital said, "You bring the dead body." Then we so-called dead body we will certify. Then we called for a ambulance from the Ernakulam Karyagam. But Ernakulam Karyagam did not have their ambulance right then. Then they had a tie-up with one of the hospitals, Krishna Hospital, and the ambulance which came was from Krishna Hospital. Krishna Hospital I had contacted, and even after revealing my identity, they said, "No, we don't do that. You better do it in government hospital." And this ambulance driver He said, we will take it to our hospital, Krishna hospital. I said, I contacted the doctor. Doctor said, no. No, let us take us, sir. And we took the dead body to the hospital. He had some word in the inside, went inside and had some word. Then the doctor came out and did the certified the death.
You know, because everybody is afraid of, because sometimes later some.
So they have to do the ECG. They did it, the doctor did it from the ambulance itself. And doctor said, don't bring the body inside. Then you will
They will not record. They will not record.
Not only
everything.
that, postmortem will have to be there.
Then it will be
That's
treated as a
because
death from the
sir,
hospital.
that's because it's if it's dead on arrival, postmortem autopsy is mandatory.
Mandatory. Brought dead. In spite of that, she certified that body was brought dead after doing the ECG.
Anyhow, sir, it's a good topic.
Yes.
Where there is some relevance in because in a criminal case, every inquiry or every investigation, every collection of material is having some role to play to prove the guilt or otherwise of the persons involved in the incident. Thank you very much, sir.
Thank you, Ramachandran sir. And before I go to Prem, Rao sir.
Krishna was wanted to say something.
Yeah, Krishna, of course.
Sir, I wanted to ask a magistrate who conducts an inquiry under section 174, whom is he required to send the report to?
174, you mean what inquiry? About the inquest?
Yes, inquest.
Inquest, magistrate, when the police officer conducting an inquiry or investigation, request the executive magistrate to hold the inquest. Magistrate is to magistrate is to hold the inquest, but actually in practice is the police officer who will do the inquest in the presence of the magistrate.
No, even the section says it will not be signed by the investigating officer, the person who is conducting the inquest.
When a judicial
Police officer.
But executive magistrates are authorized to conduct inquest. That is what 174(4) says. Clause 4 of section 174 says these executive magistrates shall authorized by the government shall hold inquest. They are the person to hold the inquest. But in real,
it conducts an inquiry under section 174,
yes,
and report, whom is he required to send that report to?
To the executive magistrate.
Executive magistrate.
Where the FIR was registered.
Judicial magistrate would send it to the executive magistrate.
Not judicial magistrate.
No. What he says was, suppose a judicial inquiry was conducted, magisterial inquiry was conducted by the judicial magistrate in the case of a custodial death and a custodial rape.
Yes.
Then right. where will have to be the report will have to be sent is the question. It appears, is it not, Krishna?
Yes, sir.
But there the section itself says when a person is missing while in the custody, then custody means there is somebody responsible for his missing, for the man missing. Then when a rape of a woman is committed while she is in the custody, there an offense is disclosed. No question of executive magistrate being informed. The judicial magistrate, the matter will have to go to the judicial magistrate.
No. What he says is, suppose the inquest is conducted by him, then where he is expected to send the report?
Inquest by the magistrate.
By the magistrate.
Judicial magistrate. Judicial magistrate will not do that. He will only, that's what the section says, 176, not 174. 176 says, see,
because whatever the police officer or the executive magistrate will have to do has to be done by the judicial magistrate or metropolitan magistrate in the case of a certain category of offences.
Yes, when the death or disappearance or rape while in custody happens, then it is the judicial magistrate who has to conduct the inquiry under 176 1A.
Can it be said to be an inquest or a preliminary inquiry?
It is only inquiry. It is only inquiry. It is not inquest. Inquest separately you will have to get it conducted. You will have to separately get it held. Inquest you will have to separately get it held. He is not holding the inquest. But then there is one says where the judy subsection 3. Whenever such magistrate considers it expedient to make an examination of the dead body of any person who has already been interred, the section is inferred, is a mistake, interred, that is already cremated, already buried, and Already
In order to discover.
In order to discover the cause of his death, the magistrate may cause the body to be disinterred and examined. Cause to be examined, cause to be disinterred. So he is not doing it. He can cause it to be disinterred and examined.
After conducting the
Exhumed and examined.
After conducting this inquiry, when he draws the report, whom is he expected in the report?
Actually, he is the jurisdictional magistrate. Is it not? He is the magistrate within whose limits the occurrence took place. So he is the jurisdictional magistrate. He can register the. He can make a record. He can take cognizance.
Just like 164 statement is being recorded by the magistrate, but that is being
Not
sent
only
to
that, not that. Here he can, because it may fall under section 190 last clause. 190 clause 1, subsection 1 clause, last clause. C.
He can take suo motu cognizance.
He can take suo motu cognizance. But provided there, and of course, he need not know who the offender is. He need only take cognizance of the offense. Which is revealed.
Thank you, sir.
Sir, CSR sir has put the hand up. Sir, you have a query? Yeah, please.
Raghuraman, sir.
Sir, definitely, sir.
Professor Raghuraman.
Sir, in our state, the magisterial report will be given to the CM or Home Minister for registration of an FIR on the basis of if any custodial rape or death takes place.
CRPC doesn't say so.
They are giving and they are placing it before the assembly also. Not only for departmental action but also for registration of FIR also.
That may be for political mileage. CRPC doesn't prescribe anything.
Political mileage, naturally it is political mileage, but they are also registering the FIR on the basis of that report. The DGP office will take care of it, and Director of Public Prosecutions office is also involved in that situation. There is one office which is known, I think your state name also having that DPP office. So yes, they are taking care of that. I was told.
But actually, when such things happen, falling under one capital 376, 376. I'm sorry. 376 1A, death or rape takes place, then FIR would have been already registered.
That is also there.
FIR would have been, of course, if it is done in police custody, they may delay the registration of an FIR. They may.
In Telangana state, these type of police custodial deaths are every year 3 to 4 deaths will take place. It is a big political problem and also administrative problem. Recently also one person was taken to police station. He was found dead in the custody and the inquiry was conducted.
No, I think it was on the basis of the direction given by the Supreme Court that the ministerial inquiry is being incorporated and section 1A was added, it appears.
Yes,
earlier. Made it compulsory.
Maybe it is that Shivanna's case. Maybe, I'm not sure.
I think it is by Justice Balakrishnan was one.
Shivanna's case. Was it not Shivanna's case, Prem?
Which one?
That 1A, 174, 176, 1A. Maybe the result of that Shivanna's directions in Shivanna's case. Maybe.
And
Justice KG Balakrishnan.
Yes.
I don't remember the.
I think that is a case by Justice Balakrishnan.
Sarkari Shivanna versus State of Karnataka.
No, the manual says no police officer will be allowed to even enter into that inquiry premises. During that, all the police officers attached to the police station, they are totally prohibited from entering into the inquiry conducted that place inside the police station. Or like the ACP office also they are conducting now. Nobody is allowed in that situation. All the police officers who are in the station, working in the station, same station, they are not allowed. That is also there. I share with you. This is, I think, the practice is followed in our Telangana state.
Yes, These are things for which you don't find any provision in the CRPC.
It is there, not there, but naturally they will have, what do you call, they want to protect their colleagues. In such a situation, there is a.
I think in a similar issue, I think National Human Rights Commission also raised certain procedure to be followed. Custodial death and custodial tortures.
Yes.
Certain guidelines are issued by the National Human Rights Commission. That's how this will be done.
Thank you, sir.
They also used to call for reports in this regard.
Rao sir, please do. Any comments?
No, it's an evening well spent. It's always a pleasure to hear Justice Ramkumar. And it was really nice. It's a good topic. I mean, I don't deal much with this, but still it is nice to know and learn about these things. And I thank Justice Ramkumar for the effort that he takes in presenting his papers. That's very beautiful. That's all. Thank you, sir.
These are the usual questions which crop up for resolution before our courts. That's why I prepared those questions, so that once you answer those questions, the doubts, lingering doubts will vanish.
It will vanish. Crystal, that's why I said it's crystal clear. So
sir, I mean, let us not empower Rao sir even more. Even otherwise, he's so empowered.
No.
Absolutely.
Okay, over to you, Prem, for your concluding remarks, please.
Absolutely amazing lectures.
Thank you. Thank you.
He is giving really with everything on fingertips. Citations, judges' names, who wrote the main judgment also. Such a wonderful.
After assiduous research only.
Yes, definitely. Very excellent research.
Thank you, sir. Prem, over to you.
Thank you, sir.
Well, as everybody has commented, it was a wonderful evening and we got a lot of learning. And just to summarize, only 2 or 3 sections came into play. Sections 174, 175, 176. And we know that these particular sections have a very limited scope also. And what we could gain, or rather a summary of what Ramkumar's lecture was, one, the object of this particular proceeding, the inquest, the object is merely to ascertain whether a person has died in a suspicious circumstance or there is an unnatural death. And if that be so, what is the apparent cause of the death? And the inquest report, as we see, is prepared under section 174 CRPC. And the object, again, it's only the unnatural death. What the cause of death is. And we saw the question regarding the details as to how that particular disease was assaulted, who assaulted him, the names of the assailants, everything, as Ramkumar said, it is foreign or alien to the ambit and scope of the proceeding under 174. And the purpose of this particular report is merely to make note in regard to the identification marks, whatever you see on the body, whatever that be. And it is not a substantive evidence. And we saw that mentioning or non-mentioning the name of the accused or the eyewitnesses in the inquest report, that also is not fatal. Due to the non-mentioning of the name of the accused, it cannot be inferred that the FIR was not in existence like that. So, in effect, Ramkumar sir, we got a lot of learning, even though these 3 sections seem to be so small and almost like inconspicuous insofar as the entire CRPC is concerned.
We have to thank Sudhish for this.
Yes.
Advocate Sudhish.
Sudhish, I think Sudhish is not here. I cannot see Sudhish. Anyway, thank you so much, sir.
He ignited the fire and left.
Thank you. Yes, Shyam, you are concluding.
For session.
Yes.
As we come to the end of the 281st session, I would say, like Rao sir said, a evening well spent. Though a topic minuscule in nature, but with wide ambit and wide ramifications, we were able to deal with that. And like Ramkumar sir said, thanks to Sudhish for igniting the thoughts, and Ramashan sir also said that. In fact, it was his thought that we had this topic today. But I'm sure that all those persons who are hearing it directly or indirectly later on would be benefited by this, because this has been, and this is a topic which has been agitating the legal minds for quite some time. It's in fact, sir, a wonderful evening, like said by everybody. Thank you, Ramkumar sir. Thank you, Ramashan sir. Thank you, all of you, for being part of this little evening today. Till we meet again next week. Do take care and stay safe.